Joined today by Michael Moran and Conor Dalton from the Guidance and Ethics Committee, and they're going to give us some essential solicitor update on legal privilege. So guys, I hope you're not too harassed by all of that, and you're ready to go. So you're very welcome to join us today, and thanks everyone for being patient with us. So we'll move on to the first slide.
Good afternoon, everybody. Michael Moran here. I am a solicitor, although now retired, but I'm a member of the Guidance and Ethics Committee of the Law Society. And we're just going to give you a brief overview, myself and my colleague Conor Dalton, on both privilege and confidentiality. So moving on to the next slide, you will see that the grounds are privilege, but there are other categories to consider: settlement negotiations, correspondence without prejudice. When can it be waived? We'll say a little bit about that, and then Conor will talk briefly about confidentiality and GDPR. The basis for privilege is that it's in the public interest, and privilege is actually a common law right that has been around for quite some time. And privilege can be divided into two categories: private privilege and public privilege. The purpose or the rationale for privilege is the attainment of public policy, and to get a balancing test where the public interest in the production of documents and of a particular document in which the privilege is claimed is waived in withholding that documentation from production. And getting on to the basis is that in the context of a solicitor-client relationship, it allows the client to talk to his solicitor freely in the situations that we will determine, and without having the concern that what he says, or he or she says, will be revealed at a future date. Next slide, please. Right.
You're better going, Michael.
No, a privilege is considered private if the objectives were established at the time that the definition of privilege was established. And as I say, it's the fostering of the relationship of the trust between the client and the lawyer, which outweighs the right of the opponent to obtain information in furtherance of the litigation that has been perhaps being considered, or legal advice that's obtained. Other examples would be in the case of informer privilege and statutory privilege. But there are also cases where it has been in existence but has now been slightly watered down, like the sacerdotal privilege, where in the confessional the priest now has an obligation to report instances where he is informed in the confessional of any matter relating to sexual abuse. And that does slightly change matters in the context of what was there before. If we move on to the next slide, there are certain categories of privilege have been rejected by the courts, and they include a journalist and his or her source, a doctor and his patient, a banker and his or her customer, and an agent and principal. They're the principal categories of where they have been rejected. In the context of public privilege, it's considered public when government agencies and their employees try to maintain a confidential relationship and wish to withhold documents from production. However, unlike in the case of legal professional privilege or legal advice privilege, it's not up to the government agency, like a department, to decide what documents will or will not be produced. It's up to the courts to decide on the basis of the public interest and the balance in producing the documents as against withholding the documents. And what will be done would be that the documents will be listed out in an affidavit, and the courts would determine on what basis those documents can or cannot be disclosed. Next, we have the question of waiver of privilege. Well, privilege, I'm going to do this in reverse. The duration of privilege: once privileged, always privileged. So no matter what happens, it doesn't affect the whole concept of privilege. Even if the client passes away, the documents will still remain privileged. However, it's possible that the executors could waive that privilege if they so saw fit. But the waiver of the privilege is not a matter which the solicitor can determine. It's only the client can decide whether or not privilege will be waived. And if it ever did arise in the context of waiver, well, then any instructions should be obtained in writing from the client to the effect that the solicitor can disclose documentation which were formally privileged to whatever or to whomever requires it. Privilege and copy documents, basically copies of documents are not privileged. There are, of course, one exception in where documentation has been prepared for counsel in the context of court proceedings. But the privilege really only attaches to the original document, which is being claimed to be privileged. The procedure for claiming privilege will be by way of affidavit as set out in the rules of the Superior Court, Order 13, Order 31, Rule 13, which requires an affidavit to be produced. And again, the documentation are listed, and the judge will determine on the basis of the documentation described in the appendix whether or not the document will be privileged. The judge does not have to read any of the documentation, but it's the description of the documentation will determine whether or not it is privileged. Moving on then, the legal professional privilege in the context of a lawyer is communications between the client and lawyer which are made for the purposes of giving legal advice and in the course of the legal relationship. Legal advice would be advising person as to their rights and what they may or may not do. So that would be privileged, and all documentation relating to that. And the lawyer's work in preparation for litigation would also be considered to be privileged. And that's probably the principal category as such. But the litigation must be in existence. And I'll give you an example of where privilege was claimed, where litigation arose subsequently. There was a case involving the National Maternity Hospital in Holles Street, where there was a difficult birth, and the matron said to the nurses who were on duty at the birth to make a statement as regards the circumstances of the birth. And subsequently in proceedings, there was a claim for privilege in respect of these statements that were made by the nurses. And they were declined on the basis that there was no litigation pending or threatened at the time that the statements were made, and therefore they were not privileged. One of the things that are situations where you're most familiar with is settlement negotiations, and these cases are a situation where the courts would encourage parties to resolve disputes themselves rather than to have a court determination. And consequently, they give a certain status. It's not under the category of legal professional privilege, but it's under the status of settlement negotiations that the court would encourage the parties, as I say, to settle their dispute amicably. And to do so, they will provide that anything that is discussed or exchanged in these situations will be granted a certain degree of privacy and privilege. Similarly, without prejudice, so that would come into a similar category, where if you are made an offer in say a personal injuries case, it's without prejudice to whatever, and then those that correspondence will not be produced as such. But just by putting the heading without prejudice on correspondence doesn't mean to say that it will automatically be protected, because the courts may drill down and look at the correspondence to see what in reality it's all about. Moving on to the next category is distinction between legal advice and legal assistance. I've mentioned that legal advice is privileged in that if you're telling a client what his legal rights are, as distinct from legal assistance. And legal assistance would be, an example would be in the context of if you are assisting a client preparing a contract, and after receiving instructions, you draw up the contract, that would be regarded as legal assistance. Another category would be where a solicitor maintains statutory books on behalf of a client in what used to be called company secretarial matters, now I suppose is corporate governance. They would not be privileged as such in the normal course of events. You have what's called a call-to-bank letter, which is a letter which is sent out but without prejudice as to costs, would also maybe to a certain extent be privileged. There is no privilege where fraud or the person making the communication is guilty of moral turpitude or dishonesty. Obviously, that is a category which would automatically negate any claim that would be made for privilege. Moving on then to the next one is that the public privilege must be particularized. And as I've said already, the court is not required to examine each individual document described, and is to get a balance between the executive and the judiciary. And arguments in favor of non-disclosure, like the vital interest of the state, the preservation of international relations, the proper functioning of the public service, detection of crime, and cabinet privilege, will be cases which will be put forward in the argument to claim privilege in the context of public privilege. Moving on then to the next slide.
That's it, Michael.
Thank you very much.
So thanks very much for going through it in such haste. I suppose we have limited time, and I know Michael, Conor, you're up next.
Well, I would try and be as brief as I can, because I understand that everybody here attending this is on their lunchtime and that they have important things to do. So I'm going to be a very brief summary of confidentiality, which is of paramount importance in a solicitor's office. And my attitude is, you can't have confidence in a solicitor unless you have confidence in the confidentiality of that solicitor's office. That is quite a paramount observation, in that I love the phrase, the only people that you have to tell the whole truth and nothing but the truth to are your doctor and your lawyer, because without that, they can't give you the best advice. Now, in saying that, when clients come to you, they come to you and they expect a certain level of confidentiality. They don't expect their dealings to be discussed with third parties or members of the public. There is obviously a certain element which you need to use to enable you to do your job, but you need to get very clear instructions from your client as to what is to remain confidential and what can be disclosed. When you're dealing with any settlements or negotiations, make sure you have very clear instructions from your client as to what can be said. Okay. GDPR has obviously been a whirlwind entity, shall we say, and you have to cover yourself as well. If in doubt, don't send it out. That's kind of the attitude that I would have. So if you think that there's something that shouldn't be disclosed to the public, don't. But get very clear instructions from your client as to what can and can't remain confidential. Can't remain confidential. In the modern context, social media, people often forget that social media is a public forum, and things that you might want to say may become public knowledge by breach of confidentiality, and you might find yourself in difficulty. My attitude again is, don't say it unless you have instructions from your client to do so. In the office, obviously, you try to make things as confidential as possible. If you're meeting people, don't have any other files open where they could obtain other information from other parties, because you could be in breach of confidentiality for that party. You've got confidentiality with colleagues. You've got confidentiality when you're dealing with settlement negotiations, and Michael has touched on that with privilege. You obviously have to have a certain modicum of what you can disclose to the opposite side when you're dealing with those negotiations, to make sure that you can get the best outcome for your client. But come back to the principle of don't do anything unless your client has given you the instructions to do so. Confidentiality can be waived and can be, court order to be removed, and the statutory provisions for when confidentiality might not be the case. And they are likes of reporting in the case of childhood abuse, or reporting when somebody's health might be very detrimentally affected, and if there's a threat of murder or there's a threat of anything else. I'd refer you to the guide on good professional conduct, which has quite a detailed section on both confidentiality and privilege. But the general rule of thumb with confidentiality is, if in doubt, don't say it. With confidentiality, your office and your service providers are very important as well. Most of us operate a system where we are connected to the internet, such as now, and you need to make sure that your internet provider is secure and that none of your information can inadvertently be accessed from third parties, because you might find yourself in breach of GDPR and in breach of confidence. Family law files, I don't think I need to say anything about the fact that they have to remain confidential. Even after somebody might have passed away, if there's a doubt about the confidentiality of the nature of a file, you're better to seek guidance from a court instead of just releasing documentation. Wills are the ownership of originally the executor, but when they're gone, it's then the executor. They shouldn't be released out unless you have the consent of the said executor. Even accounts should only be sent out if requested to do so. They shouldn't be sent out en masse, because you could be breaching confidentiality, because you shouldn't be telling everybody everybody's affairs. Any transaction that you do, from a conveyance to a personal injury to medical negligence to anything, your client doesn't want you to tell people what's going on. They're engaging you because they want you to deal with their matter in a matter that's confidential. If they tell you that they want certain things disclosed, then you can disclose them. Otherwise, don't, is the short answer. Okay. What's the overriding principle that I think I've said here? Be confident in your clients, and they have to, in order for them to be confident in you, they have to maintain that there's confidentiality. Okay. So when you have any file, that file belongs to the client. And although you are advising him based on the information that's been furnished, that information should remain confidential. Your staff shouldn't discuss it. Your third-party service provider shouldn't discuss it. Even when you're dealing with the matter as a solicitor, you shouldn't discuss matters on the file unless you have the authority to do so from your client. Everything should remain confidential until you're told otherwise. Okay. It's better to keep the secrets closer to your chest. Okay. When we're in settlement negotiations, we don't always show our full hand. You need to know what your client wants to disclose to the other side, or is prepared to disclose to the other side, in an effort to get the negotiations ongoing. You will obviously advise them that it might be prudent to disclose certain aspects which might be beneficial to a case, but you might also advise not to disclose certain aspects which might be prejudicial to your case. Your client is going to be the one who's going to determine that. Okay, so take a file, take instructions, they're in confidence, and they shall remain so until the client determines otherwise. Okay, so that has brought us nicely up to 25 past, which I know that there's a couple of questions here and there. And again, this is a very short whistle-stop tour of confidentiality.
And we did say that you are going to be speaking at the SkillNet Cluster event in Carrick-on-Shannon on the 25th of June, or 25th of May, and there's still seats available, but you'll give a much fuller in-depth analysis of this situation. So thank you very much.
Oh, I'll be saying a lot more about privilege. I didn't mention, if I may just say one thing, that in-house solicitors, by the way, are also covered and enjoy the benefits of privilege, except in one exception, and that arose from a decision of the European Court in 2010 in what's called the AXA Nobel against the Commission, where that in competition cases, the solicitor or the in-house solicitor does not enjoy a privileged position. I think it may have arisen because of the differences between a common law system and also a civil law system, in the sense that there's different rules apply. But just to note that in regard of in-house solicitors.
Michael, while we have you there, there was just a comment there about original documents.
Yes. Basically, the privilege and copy documents, basically it doesn't apply. Well, I won't say it doesn't apply, but there's a less importance given to copy documents. Except I would submit that in one case, that where the original has been lost and there's certified copies, I know that in the context of production as real evidence, that a copy document which has been stamped has been accepted as in substitution of the original documents. Maybe just to mislead you slightly, that there are, like every rule, there are exceptions to it. So, but just be careful, as I say, about making copies of the documentation, and particularly if the copies of the documentation have gone outside your office, then you may have a problem, because you have disclosed it to third parties intentionally or otherwise.
Thank you very much. I know we did get a query in on the email. Conor, if you want to just give a brief synopsis of it.
We got a query in about the new powers of attorney and the disclosures that are now obliged to do to the, I want to get this title right, the Decision Support Service. Now, this is very early on, and this is, in my opinion, more correctly addressed to the probate committee. But this would be, in my mind, akin to a court order. And when there's a court order, when there's a statutory basis to disclose things, we can't rely on privilege or we can't claim privilege over something that we're statutorily obliged to do. So the query was whether or not a solicitor should be able to rely on privilege with regard to the execution of an enduring power of attorney when a request is made from the decision support services. That's a request that's a quasi-judicial request, so it should be complied with. But again, you should take instructions, and if your client has a valid reason for objecting to it, you should be able to state your case and outline it. But be aware, this is a statutory obligation, and you might find yourself before a court and being told in a rather certain way not to do that by a court if it's found that there was no valid justified reason for not disclosing it. So there are exceptions to privilege and there are exceptions to confidentiality, so just be aware of it. But on that particular case, I think it would be prudent to wait and see how the system goes on, because it is very much in its infancy. Anything that I'm saying is not a reflection of the Law Society. It is merely my opinion as to how it would be interpreted based on my interpretation of the legislation and the overriding privilege provisions and confidentiality.
If I may just add, there may very well be challenges as to part of the Act. And again, there may very well be the fact that the question of privilege may arise. But we'll remain to be seen what happens in due course. And in practice as well, I might add.
Conor, I don't know whether you can see that. Just
I saw half of it. If you wouldn't mind just putting it up, because I saw the problem is
it says a difficulty. Well, it's a difficulty is that at the time you can't take instruction, client will be subject to a DSS investigation. I don't understand that.
I think the issue that is being raised there is where you have an issue in getting instructions from your client where they mightn't be fully compos mentis or they mightn't be able to do that, whether or not that investigation or that preliminary advices would be subject to a DSS referral. And this goes back to what the DSS is trying to do, which is we're moving from the best from a system where what's best for the donor to what the donor intended. So it's what the donor intended, regardless of whether it's in their best interest or not. So I think that the spirit of this agreement, for want of a better word, is that it is there to make sure that the decision support service are aware that the donor made the decision and that decision is being carried out in accordance with their wishes, not their best interest. I think that's probably what the query is, but I understand there may be difficulty in getting instructions. All I can do is to keep a detailed attendance note and try and keep as detailed note as you can to try and assist in that situation. So if you have any question mark over competence, decline to act and then refer to the donor for a doctor and make sure that you are satisfied that the person can give instructions. If they're no longer compos mentis, they can't give instructions, simple as that.
Okay, and we're sort of in the final minute now, so there's some future sessions just up there on the screen, but Michael, Conor, do you have any just final remarks? And thank you very much for taking the time to talk to us today. I know you're going to be in Carrick and Shannon next week, the 25th of May, for a cluster event, so we'd encourage you to attend at that for a much more fuller explanation of what we've provided today. But thank you very much.
Thank you very much.
Thank you.
If you guys have any final remarks?
If you have any queries, just let Justin know and we will come back to you.
Yeah, and we'll try and deal them as best we can. Now, if we can't deal with them, we might direct you to who might be better suited to do it. That's probably the best way, just in case there's somebody else. Yes, I don't think there's any.
Yeah, there's no difficulty in the slides. Yes, Justin, I'm sure will make them available.
Yeah, at the end of the week, we will have them up on the Law Society website under information sessions, and there'll be a recording of the copy sent out later, and it's available on the YouTube channel also, the Law Society YouTube channel. Of where there's an extensive sort of collection, but this one will be ready on Friday. So yeah, that's great.
I'm going to be very rude and say, because I did my talk on confidentiality, I thought it would be prudent not to disclose them and keep them in confidence.
Very good. Thank you very much. Listen, guys, you've been a good sport today. Thank you very much for joining us. Thanks everyone for coming along. Hopefully you'll join us on June 7th and for the future sessions in June. So thanks a lot, Sloan, August Gurmagan.
Thank you.
Thank you.
Thank you very much.
Bye-bye.